Hello, and welcome to this Constitution Unit event about parliamentary approval of military action. I'm Lisa James. I'm a research fellow at the Constitution Unit, and I'll be chairing today's discussion. Parliament's role in approving military action has been a source of perennial controversy in recent decades. It's often said that Tony Blair set a precedent in 2003 when he sought Parliament's approval for military action in Iraq. But the limits of that convention have long been contested, and the way that successive governments have approached consulting Parliament has often been inconsistent. The topic's been raised once more recently by the airstrikes in Yemen. And another related recurring question is whether Parliament's role should be more firmly codified, perhaps even in legislation. So what should Parliament's role be in approving military action? How should this role be guaranteed? And how might the changing nature of warfare influence our thinking on this topic? To discuss these questions, I'm joined by a fantastic panel. Our speakers are Dr. Veronika Fikfak, Associate Professor in International Law here at University College London, Dr. James Strong, Senior Lecturer in British Politics and Foreign Policy at Queen Mary University of London, and last but by no means least, Sir David Lidington, Chair of the Royal United Services Institute, RUSI, former Conservative MP for Aylesbury and former Minister for the Cabinet Office, Lord Chancellor and Leader of the House of Commons. So each of our panelists is going to speak for around 5 minutes, and after that the four of us will have a brief panel discussion, and then we'll open up to questions from the audience. So if you have a question, you can submit it through the Q&A function at the bottom of the Zoom screen. My colleague Tom Fleming, who's here on screen, will select from among them and put the questions to the panel. By default, he'll also share the questioner's name, but you can submit anonymously if you wish. This whole session, including the Q&A, is being recorded, so you might want to take that into consideration when you decide whether or not to submit your question anonymously. We'll be posting the video soon after the event, and we'll also make it available via the Constitution Unit podcast. So with no further ado, I'm going to hand over first of all to Veronika to kick us off.
Thanks so much, Lisa. So as you said, and as you started in the introduction, ever since the Iraq War in 2003, scholars and also commentators have really argued that a constitutional convention exists, which requires that the House of Commons should have an opportunity to debate and to vote before troops are deployed. And in 2011, the government explicitly recognized for the first time that such a convention exists, and that was done in the Cabinet Manual. The Cabinet Manual specifically states that before troops are committed, the House of Commons should have an opportunity to debate the matter. And then it continues to say that the government will proposes to observe this convention except when there's an emergency and such action would not be appropriate. So what I'd like to do in my 5 minutes is really, I want to focus on outlining the current scope of the convention. And in that context, I'd like to make 3 points. The first one relates to the fact that the manual only speaks about a debate, not a vote in Parliament. The second one is that relates to the timing of the Commons debate. And the third one relates to the situations that are excluded or appear to be excluded from the convention. So on the first one, which is the question of what kind of involvement Parliament really is entitled to, a number of people have, during the recent month when we've been discussing the Houthi attacks in Yemen, a number of people have called for Parliament to be consulted, but also to have a vote on any military involvement. As the manual currently states, the wording it is using, it really is limiting the role of Parliament to have only an opportunity to debate. Vote, therefore, doesn't appear to be guaranteed. And in fact, when Keir Starmer gave several statements about how he would change the approach to this question of allowing Parliament's involvement, he actually seems to have expanded the role of MPs to give them a right to vote, which seems to suggest that he would go further than the current Cabinet Manual provides. So that's on question number one. Question number two relates to the timing of parliamentary engagement. And the convention very specifically talks about that parliamentary involvement needs to take place before any military action takes place. There are a number of examples where Parliament was involved and debated the issue after the fact, and that was the case including in the most recent case. But the reality is that if Parliament is really to have a role and to have a say on the matter, any consultation needs to be beforehand. Of course, this kind of involvement is very risky, as we saw in the case in Syria in 2013, when UK government was asked by the US government to intervene together against the Assad regime at the time when it used chemical weapons, and that vote, the government in that vote was defeated. But the involvement after the fact only has confirmatory role. And so it is seen as somewhat problematic in the context of what the Covenant Manual provides. And my third point really relates then to the question of the scope of the convention and what kind of, and the phrasing, if you'd like, before any troops are committed, as the manual puts it. Through practice, a number of situations seem to have fallen outside of the application of the convention. So, for example, special forces involvement is really never discussed in Parliament, specifically not prior to such engagement. Secondly, in 2015, we had a number of situations where drones, so unmanned aerial planes, were used to strike specific targets in Syria. And in those kind of contexts, there was no prior approval and prior involvement of Parliament. There are also a number of situations where, for example, the Security Council provided specific authorization for intervention, like in the case of Libya and Mali. And in those cases, Parliament was also not involved prior to the airstrikes or deployment of troops. And then the fourth category are emergencies. And there it seems that the timing of the intervention really makes approval prior to the deployment or prior to airstrikes almost impossible or unlikely. And I think this emergency argument is the argument that has been used in relation to the the most recent examples of the Houthi strikes in Yemen. But as you said, the practices has been inconsistent, and the only thing we can really say at the moment is, looking both at the statements of the current government, but also of the leader opposition, what both sides seem to agree to is that the convention at the moment applies. So prior involvement of Parliament, having a debate, that it applies only when ground troops are committed. So when we are sending boots on the ground, and that would seem to exclude airstrikes, or it would seem to exclude interventions for defensive purposes. So what is then the state of the affair? I've got like a little picture that I wanted to share. I don't know if Ed can do so. Super. Thank you. So in some sense, when a lot of us discuss what the scope of the convention is, the impression we have, or the discussion, is always sort of thinking about convention as this really broad space. But in reality, when you take little chunks out, for example, involvement of drones, that we've excluded when we deploy special forces. Security Council authorizations appear to not require parliamentary approval prior to the deployment. And then emergencies, when you take each one of those chunks out, what actually remains is a very narrow space in which Parliament seems to have a say, and a prior say, before troops are deployed. And that is only in the context of sort of traditional warfare, which is the sending of ground troops on the ground. So I'll stop there. Thank you.
Sorry, slow unmuting there. That was fantastic. Thank you very much, Veronika. And that really kind of pinpointed some of the ambiguities or the potential gaps in the convention as it currently exists. I'm sure we'll come back to some of these points. James, let me hand over to you.
Thank you. So Veronika has talked about what the position is right now. I'm going to talk a little bit about why Parliament should be involved in military deployment decisions, and a little bit also about how that should happen. I'm going to focus on two things. I'm going to make a slightly contradictory argument, I think, because on the one hand, I'm going to say I think it is a good idea for governments to seek prior parliamentary approval before getting involved in major military action. But I'm also going to say that I don't think it would be a very good idea for the UK to introduce a War Powers Act, to have a legal obligation. And I'll talk a bit more about why I think that in a minute. So firstly, on why I think it's a good idea for parliaments to have parliamentary authorization. Ultimately, because the United Kingdom is a parliamentary democracy, the power of the government comes from its possession of a majority in the House of Commons. And one of the things you get when you hold an authorization vote is you make it clear that you do in fact have the support of your majority behind you. And governments often feel they can rely on their majority, and they often can rely on their majority. But military action is one of those things, a bit like we saw with Brexit, that cuts across party allegiances in ways that are not always predictable. Either you have a majority behind you or you don't. If you have a majority behind you, you will win a vote on military action. If you don't have a majority behind you, you want to find that out before you get involved in a conflict. Otherwise, you risk winding up like Lord North, Lord Aberdeen, or Neville Chamberlain, one of the series of historic prime ministers who found themselves trying to lead a war without the support of a solid majority behind them and wound up losing their jobs partway through as a result. The second reason why I think it's a good idea to hold a prior vote is because there are strategic benefits from doing so. To put it simply, securing parliamentary approval for military action signals to both allies and to enemies that you have a firm domestic support base. This is one reason why when Winston Churchill became Prime Minister in May 1940, one of the first things he did was call a confidence vote in himself to send that signal very clearly to France and to Germany. Germany had just invaded France in the middle of the crisis that led to Churchill becoming Prime Minister, to signal that he was firm in power, that his government was likely to succeed. This is an even stronger position if you can persuade the opposition to vote with you as well. In fact, in 1950, at the start of the Korean War, it was Churchill as leader of the opposition who pressured Clement Attlee as Prime Minister into calling an authorization vote before the UK got involved in that conflict. Similarly, in 2003 or in 2011, the government won solid opposition support for what it proposed to do. That sends a signal again, both allies and enemies, that a future change of government is not going to lead to a change of policy, which can be quite a significant strategic asset. One argument against holding parliamentary votes is that they can make the UK less reliable as an ally or less threatening as an enemy. But if you call a vote and win, it has the opposite effect. It sends that signal that, okay, we may be a parliamentary democracy. Parliamentary democracies may be a bit messy, but we are solid on this. We are agreed on this. And thirdly, that leads to more of a sort of domestic political benefit. If you can bind your potential critics behind you in what you're trying to do, that can give you a level of security later on, especially if things don't go according to plan, which often they don't when military action is involved. That might be a matter of getting your potential backbench critics within your own party to vote with you, or ideally, it means getting the opposition to vote with you as well. Conservative support for the invasion of Iraq in 2003 was very, very helpful for the Blair government in the run-up to the 2005 general election. The war had not gone according to plan, the weapons of mass destruction had not been found, but the Conservative Party wasn't really able to make any electoral hay out of it because they were on the record as very strongly voting in favour of the invasion. So that was a really significant political benefit for the Blair government there as well. And indeed, George W. Bush had similar advantages in the United States, having once secured democratic support for the invasion of Iraq. So I think that it's quite a good idea if you are a government to get Parliament to support you taking military action. And I would extend that to basically any significant military action that's going to last any period of time where there's any realistic prospect of something significant going wrong, which is why I would push back against some of the ways in which the convention has been narrowed in recent years. I would say you can get away with not holding a vote in some of these smaller conflicts, but actually I think holding a vote is actually a smart thing to do. Nevertheless, I'm not in favour of a War Powers Act. I'm not in favour of codifying this legally. Three main reasons for that. Firstly, I think there is general agreement, cross-party agreement, that it would be a bad idea to make questions about military deployment justiciable, to get yourself into a position where you might have Parliament vote in favour of a military action and then have a court subsequently rule actually the vote was conducted in the wrong way and the action is not lawful after all. I think most people, even most advocates of war powers legislation, agree that would not be a good position to get into. Secondly, I think one of the lessons we've learned from the experience of the Fixed Term Parliaments Act is that it's a bad idea just to codify one bit of the Constitution and not to codify other bits of the Constitution. Right now, we have a situation where the House of Commons has the right to approve the existence of the armed forces. It has the right to approve funding for the armed forces, and it has the right to remove the government if it doesn't want the government to continue in office. Those are already some fairly powerful tools. What we're talking about here is adding additional capacity to engage with how executive powers are used on a more day-to-day basis, which is not something we have in that kind of way across other aspects of executive power in the UK. I would be concerned that a War Powers Act would have unintended consequences, just as the Fixed Term Parliaments Act did, and that aspects of it would become unworkable because it just wouldn't fit with the political nature of the rest of the Constitution. Which brings me to my final point, which is the argument in favour of doing these things in a political constitution way. One of the great advantages of the political constitution is its flexibility. If a majority of MPs want to have a vote on military action, there's a good chance they will get one. Equally, if a majority of MPs don't want to have a vote on military action, there's a good chance they won't have one. And to some extent, that's what we've seen in the more recent smaller operations in Syria in 2018 and in Yemen in 2024, is that there was not a majority calling for a vote. And had there been a majority calling for a vote, they probably would have had a vote. They probably would have been able to get one way or another. The government ideally would have figured it out quickly and called one. This avoids the situation that you have in countries like Germany, where every time there's any kind of overseas deployment, there has to be a full vote in the Bundestag. You're not holding votes on issues that are not politically controversial, but any issue that is politically controversial, any issue where there is a majority saying, no, this actually has to come to Parliament, you still have a very strong incentive to do that. And I think that strikes a balance in a way that makes sense and fits with the broader logic of the Constitution. So I'll leave it there. Thank you.
Fantastic. Thank you very much, James. And last but not least, let us hand over to David. David, you're on mute.
Thank you very much indeed, Lisa. I agree very much with what James said and the constitutional analysis he set out. So I don't want to just repeat that, but try and add a few thoughts to it. I mean, one of the things that James is absolutely right on is to say that ultimately, governments in our democracy depend upon having the confidence of the House of Commons to remain in office and able to pursue the policies to which they are committed. We just look back at the Second World War. Although the government was not formally defeated, the outcome of the Norway debate and vote in 1940 was to precipitate the departure of Neville Chamberlain from number 10 and to make way for Winston Churchill to become Prime Minister. Similarly, after the fall of Tobruk in 1942, when Aneurin Bevan put forward a motion in the middle of World War II that this House has no confidence in the central direction of the war, the fact that the Churchill coalition government was able to defeat that very, very comfortably meant that there was that expression of national solidarity that could be read by friend and foe alike, even in what at that particular time was a very dark period for Allied fortunes. So it seems to me that there's two central constitutional truths that are the bedrock of this conversation. One is that governments have to rely on the confidence of the House of Commons to do anything. And secondly, that the conduct of war and decisions about the military deployment have always been seen constitutionally as a prerogative matter. They are decisions that are taken on the authority of the Crown. These days, of course, it is the Crown acting upon the advice of elected ministers. So the question then is, given the modern context of warfare and the precedent set by the Blair government in 2003, do we, and to what extent, need we to develop the constitutional oversight and accountability mechanisms further? Now, I, like James, would say that we should not go down the path of legislation. This was something that was looked at in detail by the Conservative Party in its years in opposition, and then coming to office as part of the coalition with the Liberal Democrats in 2010. And having originally committed ourselves to that, it was a decision that in the end we resiled from. And I remember talking to William Hague about it, because it's something he very much led on during his period as Shadow Foreign Secretary and then Foreign Secretary. He said that, it looked very attractive in theory, but it would have robbed the government of any element of surprise, and it would also have made it very difficult for a government to take action in conjunction with allies. What distinguished the conflict, both in 2003, but also the Gulf War in 1991, was that they involved the steady build-up over quite a long period of time of a formidable allied force with a clear command structure. And therefore, you knew that there would be a moment when the command was given, when everything was in place for military action to commence. And therefore, you could sort of time a parliamentary vote accordingly. Some of the more recent military interventions, some of the sort of air commitments, for example, are decisions that I recall were taken at very short notice. If the US president rings up the British Prime Minister and says, "I've taken the decision that we are going to go in tomorrow night, can you be with us?" And he's having a similar call to the president of France and to the heads of one or two other allied countries, then there's not an option to make a business statement, change parliamentary business, table a formal motion in the House of Commons, and then solemnly debate and vote upon it. That's not the real world. Secondly, I think there's a problem in how you define conflict these days, something that's going to become more challenging, not less. We already see the debates going on in the world where we discuss what Article 5 of NATO means and in what circumstances could it be invoked, about how you define a large-scale cyber attack upon one or more allies. Would that constitute an act of warfare? Would therefore a conventional response to that? Yes, I could understand that might be something where you could, if you were arguing for war powers, say that should be within its scope. What about a massive cyber counterattack by the United Kingdom or by the United Kingdom as part of NATO or a coalition of willing allies upon the country that was thought to be the originator of the cyber aggression against us? How do we deal with the military's growing reliance upon drones and upon various forms of intelligent but unmanned weaponry? At what point do we say that there is a decision that requires parliamentary validation and approval? And an act inevitably brings in inflexibility, and to amend an act of parliament is a lengthy process. So actually being able to keep up with developments in military science seems to me an initial and strong argument against looking to legislation as our first port of call. So what else could be done? I do think that it's building on a comment that Veronika made. We ought to have a look at the standing orders of the House of Commons, because I do believe that it is wise and it is right for any government, if it is committing to military action, to secure the endorsement of Parliament, and particularly the House of Commons as the elected house and the house that has sole discretion over whether to authorise the spending of taxpayers' money on a particular part of government activity, either before action is taken or within a period of time after action is taken. So a power that is comparable to that of the United States Senate in being able to determine in a given maximum period of time after US forces have been deployed in another country, whether that deployment should continue or not. And I think you can look to standing orders of the House of Commons to ensure that there is the space not just for a debate, but for a vote. It will be a temptation for any government to table a take note motion on the adjournment, where you vote against the government. All that happens is you're voting against adjourning the House at the end of the debate, and where standing orders on that type of debate usually mean that no substantive amendment can be made or accepted for debate and for a vote. Now, Speaker Bercow, of course, did interpret standing orders in a novel way during the Brexit debates to allow a substantive amendment upon what everybody had assumed to be a take note motion that was not capable of such an amendment. But it seems to me the right thing to do would be to write into the House of Commons standing orders that certain provisions to govern a ministerial statement after a ministerial statement and a ministerial emotion in the name of the Minister of the Crown, and ideally to say that the Speaker shall, within X days of British forces being committed to action overseas, shall allow a debate on the in the name of the Minister of the Crown, and this shall be amendable. That's not parliamentary standing order language, but that would be the import of the sort of standing order change that I have in mind. Question, I think, is an interesting question to debate, is whether the Speaker should be empowered under standing orders to either to insist that such a motion were tabled, or alternatively to empower the Speaker, if the government did not bring forward a resolution on and motion debate itself, to allow a motion in the name of either the Leader of the Opposition or of the Backbench Business Committee, similarly capable of amendment. So I do think it's right that we should have a tweak to our arrangements that give Parliament the power to insist on a vote and not just on having a debate. Final suggestion is that we have another look at select committees, and particularly the Defence Select Committee. If you look at what happens in Washington, D.C., the committees on intelligence and on the armed forces regularly have secret evidence sessions with senior officials and military commanders and cabinet members in the administration. The public is not admitted, the press is not admitted, the minutes of those meetings are not routinely published. And that is seen as a normal part of their work, and US administrations trust to the discretion of those select committees, particularly the Senate, one that has specific responsibilities for foreign and security matters. Now here, the tradition has always been that we have select committees that meet openly in public. The evidence is all public and published. The one exception to this is, of course, the Intelligence and Security Committee, which was set up with its own Act of Parliament, its own special arrangements, and where its reports have to be approved for publication by the Prime Minister of the day, and can be, and usually are, redacted to some degree to remove references to individual spies and to key information that might be helpful to our adversaries about how our intelligence services operate. Now, you could look at whether the standing orders of the Commons governing the Defence Select Committee in particular might usefully be amended to give the Select Committee on Defence both an overarching power and duty to monitor the conduct of a conflict in which the United Kingdom was currently involved. So it was not just an occasional big bang. You had a committee that was charged with keeping an eye on progress and holding ministers to account, but being able to do that in secret. And you could also look at whether the Defence Select Committee, with such a regime that allowed for confidential sessions, to be given some kind of oversight over the over special forces and some of the other areas that tend to be kept secret. I am uneasy, and I understand fully the reasons why successive governments, Labour, Conservative coalition, have insisted on neither confirming nor denying anything about the deployment of special forces. But it is interesting that the Australians, after they had a particular scandal a couple of years ago, did revise their arrangements for scrutiny and provided for greater parliamentary oversight. And I think that experience is perhaps something that we ought to look at here as well. I will stop there, Lisa.
Fantastic. Thank you very much, David. And that's been 3 really thought-provoking contributions. I hope that those of you in the audience are busy formulating your questions. Do send them in. We're going to talk among ourselves for a little while, but we will come to audience questions soon. So please let us know what's on your mind. I think possibly for the best thing first is to ask Veronika and James whether they would like to respond to anything that David's just said before I fire a couple of questions your way. Veronika, go ahead.
Super, thank you, Lisa. So I totally agree with both James and David in terms of the War Powers Act, right? Legislating this, I think, would make things much more difficult, much more complicated, not because only of the change in conflict, and sort of the new ways that we wage war, but also because it would bring courts into the equation. But one of the things that the opposition had also proposed is that in the process of approving any intervention, that there's a clear case for the legality of war. And that's something that hasn't been, statements are made in Parliament in terms of the legality, and the UK as an international force obviously needs to report. For example, in the Yemeni intervention, the UK sent Article 51 UN Charter statement to the Security Council saying that it was acting in self-defense together with the US and then later Denmark. So that the fact that the legality would become part of this process is currently not in the cabinet manual. And I think that is, so in addition to moving from a debate to a vote, I think the move is also, that would be beneficial, would be a move to make a clear case for the legality of war, where that communication with the Security Council becomes part of it. Putting it on a legislative basis, though, I think it goes too far and makes it inflexible. It makes it problematic. But in this context, one of the examples I wanted to give is that it's a really complicated area, because you can either take what James said, the German approach, but I'll call it the Danish approach. So Denmark actually at the moment is involved in the intervention in Yemen, and it started by being involved only on a non-operational level, because it said their view is that any use of force, whether that be drones, airstrikes, or troops on the ground, any of those sort of interventions constitute use of force under their view, under their definition. And they not only report them to the Security Council, but they also need prior parliamentary approval before they send any Danish person to be engaged in these kind of action. So before they helped or started helping the US forces, especially Navy forces in Yemen, they sought that approval and got that approval. And so their view is that it is sort of on one side of the spectrum, any use of force, whatever it may be, requires approval. And then the other side is, nothing requires approval, or let's be flexible about it. And the question is, should we be moving just like gradually to a more clarity or to a more consistent approach? Because at the moment the approach is quite inconsistent. Or does this flexibility and inconsistency actually work well at the moment? And I think that's a big question.
James, would you like to come in on any of that?
Yeah, I mean, one of the reasons why I sort of focus on the advantages to the government of getting parliamentary approval is I think I'm a little bit dubious about some of the arguments given why it hasn't been possible to call prior votes about previous actions. So, for example, 2018, Theresa May said, look, we couldn't possibly have called a vote before taking military action against the Assad regime. But I mean, the president was tweeting about it 8 days before it happened. Like it was possible. It wasn't really an emergency. Similarly, with the military action in Yemen in January, I mean, it was possible. That would have been fine. And would it really have made an operational difference? Probably not. I mean, we're not talking about an enemy with really the kind of defensive capabilities where that really matters if they know you're coming or not. And indeed, actually, in that case, the Prime Minister said, look, this was a one-off. He was very clear it was a one-off. That was why there would not be a vote, and that if it was a prolonged campaign, if it was proposed to be a prolonged campaign, then of course he would have followed precedent and called a vote. And of course that statement was not true, and there have been subsequent actions, which brings us back to the point that if the government doesn't recognize the advantages to itself of subjecting itself to a parliamentary vote, the onus winds up being on backbenchers, and particularly government backbenchers, to call governments out when they do this kind of thing. And that's pushing it a little bit. I think one of the issues we have is if people broadly support the actual substance, they tend to worry less about the process. But I do think the process matters for the reasons I set out earlier on. On the point about legality, as someone who wrote a book about the Iraq War, one of my most striking moments of the Brexit process was when the government was forced to publish its legal advice, which has now set a precedent for a government being forced to publish legal advice, something that had not previously happened. And obviously, as we know, the question of the government's legal advice was a big one during the course of the invasion of Iraq, and certainly subsequently as well. I mean, I take the view, I don't see why Parliament can't appoint its own counsel in this situation and take its own independent advice on questions of international law. I think it's slightly problematic because ultimately, is military action lawful or not? Well, I mean, who can you really ask to rule on that? The Security Council, yeah, but the UK government can veto it, so that doesn't really work. Similarly, in terms of, is it lawful for the UK Armed Forces to act? Well, there's only really one place that they can get a ruling on that, and that's the Attorney General, right? And if the Attorney General says it's fine, then it is fine from a domestic legal perspective. Nevertheless, I agree. I think these questions of legality are very important, and it's striking when it is clear-cut how easy it is for the government to say that it is clear-cut. It then makes it very visible when it's not clear-cut. So I think those are the main things I wanted to comment on at the moment. I think we should come back a bit to the convention. I think, as I say, emergencies, government's been pushing the definition of emergencies to include, oh, it's an emergency because we would prefer it if we didn't have to have a vote, which would not be my definition of an emergency. But I think we can also look at the ways some of these other kinds of actions could well be subject to a kind of vote. I mean, the one thing that struck me listening to David speaking was I've been doing a lot of historical research recently, and the use in previous conflicts of secret sessions of the whole House, which I would regard as, I put that in the box of technically possible but immensely impractical, but was done in the First War, in the Second War, during the Korean conflict, and it was proposed during Suez as well, as a way of enabling the government to be more frank with MPs than they would be able to be in a regular public session. So excluding strangers, unplugging all the cameras, having members of staff crawling through vents to make sure there's no journalists hiding in them, which is what they did during the First World War. All of these things would technically be possible. Of course, we don't know the quality of the debates in those secret sessions because no detailed reports were ever published, and Hansard is just blank on the subject. But it remains possible, and certainly if you did it at a committee level, and I completely agree, making better use of committees and recognizing the fact that committees have expertise, develop expertise over time, and indeed I would go further and actively promote the development of expertise on the Defence Committee and on the Foreign Affairs Committee, so that they can be resources to the House as a whole in cases when a conflict arises, so that they can offer some kind of guidance on how a particular conflict fits with the wider UK foreign policy stance. And also on the practical question, again, we often get practical questions about, can we actually do this thing we're trying to do? And there's no reason why you couldn't have the chair of the Defence Committee commenting on that on behalf of the committee. And I think, again, that would have a big impact on this kind of debate. So I'll leave it there. There's just a few additional thoughts from me.
Fantastic. One thing I'm really interested in that's come out here is this conflict between sort of the competing imperatives on the part of Parliament and of the executive. James made the strategic argument for giving Parliament to say that it allows us to give our allies certainty. It allows us perhaps to plan for the longer term, and that goes alongside the sort of democratic legitimacy argument that's often made. And David, you raised the counter arguments that flexibility is important in what can be fast-moving situations, and I find these very interesting because I think they go across the entire question of Parliament's involvement with foreign affairs. You see the same arguments being made, albeit slightly different in their details, in relation to Parliament approving international treaties and things like that. As someone who's been both minister and a parliamentarian, how do you think about that trade-off and where the lines should be drawn?
I tend to lean more towards the parliamentary side, because I think that having been in both, it seems to me that at the end of the day, the government, the executive, an executive with a majority in the House of Commons, frankly holds all the cards at the end of the day. It can in most normal circumstances expect to see its business carried through and to win the votes where there is a controversial matter at stake. Whereas Parliament seems to me to be about providing a voice for the people who are not in government, whether those are opposition parties or backbenchers who broadly support the government, but will also have views of their own, and to make sure that the constituents of MPs who did not vote for whoever happens to be in the government at a particular time have a voice as well. And so Parliament has to be about the expression of and hearing of all opinions and all questions, and then finding a way to express those and then take a decision about what the majority conceives as being in the national interest. I think there is an issue also that the senior civil service tends inevitably to support the government of the day. I mean, it's their duty, but also to think that government, because they are permanently part of government, the executive, but the civil services can be a bit suspicious of Parliament. I always remember, it's many years now, a conversation with one permanent secretary at the Foreign Office who and I said, the Foreign Office is brilliant at understanding the politics of every country on earth apart from the United Kingdom. And his response to me says, well, David, with a sort of smile on his face, he said, I suppose it's true that here in the Foreign Office we regard the House of Commons as a medium-sized power with rather uncertain intentions towards us. There's a sort of element of that about the civil service. And I can remember senior officials when I was doing the DPM job for Theresa May, who wanted us to refuse to divulge information which the House of Commons had voted by a humble address to the Crown should be divulged to a select committee. And actually, at the end of the day, I won that argument to the end with other ministers, sort of including the then attorneys, saying, look, sorry, but House of Commons says, demands this, it's passed by a majority, we have no option but to comply with it. So there are tensions there the whole time. So I think you do need an element of flexibility, and you do need a recognition in Parliament that the government is not always a completely free agent itself. So part of your reason for going to war or getting involved in a conflict may be that you as ministers have been given access to intelligence gleaned by another country's agencies. Now that information is not then yours to share with anybody else, even if it's important in your decisions. You might be able to say, we have seen intelligence from our own sources and our allies that convince us that X is the right thing to do. What you cannot do is say, look, the French have given us this piece of intelligence, or the Americans have given us this piece of intelligence. Here it is. We're publishing it as a government paper, not unless your ally gives you permission to do that. So there are some real dilemmas that have to be dealt with. And I also think that there is a complexity. I slightly disagreed with what part of what James said there. But I think back to the Libya conflict. Dominic Grieve, when he was Attorney General, was sort of sitting in Number 10 or in the Cabinet Office on occasions, going through the military's proposed target list and say, right, this one, it's lawful for you to do. That one, it's not lawful for you to attack. And at the end of the day, the military wanted to have legal cover because they did not want to expose the commanders, let alone the operational servicemen and women, to legal risk. And so the attorneys would do case by case was really important in determining certain elements of that conflict. And I think that is also the case going forward. And I think I'm not sure whether a sort of council to Parliament as a whole, I suppose it would have to be a council to Speaker, whether that would work. It might, again, this might be a select committee thing. It might be you ask the liaison committee or the defence committee or justice committee to say, to give them a power to commission external legal advice to rule on the legality or otherwise of particular military interventions.
Okay, thank you. And I think you've touched on some really interesting things there. And one of the things I was struck by in your original remarks was the question of, can standing orders be used for this? Because I think one really interesting question about this, who owns the convention? Is it wholly owned by government, in the sense of existing in the cabinet manual, or does it have some parliamentary ownership as well? One question that's sometimes been raised is whether we should be always thinking about parliamentary approval of military action on a case-by-case basis. So particularly if we think about some of those instances that you've talked about across the panel, where it may not be possible or easy for the government to bring forward specific details, is there room for Parliament to set out its views and say, okay, here are the general circumstances in which we would tend to support the use of drones, for example, as a way of giving a sort of a preliminary parliamentary steer, even where specific approval may not be expedient. James, do you have any views on whether that has legs or not?
Well, I think it would certainly be doable, and I think that I would make it slightly more specific. So you could still talk in the context of particular campaigns, particular theatres of operation, and so on. You don't have to say, oh, we're going to do a UAV strike on this building in this town next Tuesday to hit this person. That's not necessary to have the debate on whether in principle it's okay to use UAVs in Syria, say. Right. And so I do think you can distinguish between the as a point of principle, is it okay if we get involved in this conflict in this way, as opposed to getting down to the nitty-gritty of individual operations. I think the challenge is to make it specific enough that it actually offers some kind of a sense of what the House does and doesn't support, but also general enough that that it can work as a hypothetical as opposed to a real case. And I think when you go to hypotheticals, or you go to sort of big picture stuff, you lose some of the advantages of submitting an actual policy for actual approval. But I do think governments have not thought sufficiently broadly or sufficiently creatively about this, because I think there has been a tendency to treat support from the House of Commons as either the default, or seeking that support as a problem, or as a weakness, a sign of weakness. And there hasn't really been a lot of thought about how can we harness this? How can we actually use this as an asset to improve legitimacy, to send a signal about our resolve? Which I find quite interesting, because Winston Churchill, for example, very, very solid on this. He argued that there is no form of government better able to wage war than a parliamentary democracy securing the support of the parliament. And I think that again, this is what it comes back to me. I don't actually have a strong normative view on this. I think you can make a normative argument. Look, no one at the last election voted on military action in Yemen, so we can't simply rely on who won a majority to decide if it's okay. I think that there's perfectly legitimate arguments you can make there, but I've always come back to the practical argument that this for me is the best way of taking military action. And I think that for that reason, governments can do more, should do more to make use of Parliament as an asset, rather than simply treating it as a problem to be solved or avoided, circumvented.
Okay. We're going to come to audience questions in just a few minutes, so keep your questions coming in. Veronika, let me ask you in the meantime, we've talked repeatedly about how the changing nature of warfare complicates this question. Should we be thinking again about where the lines are drawn? Is committal of troops still right? And if we do think about where the lines are drawn, are there principles that we might use in doing that? Is there a way we could draw these lines that might future-proof the question slightly more than it is at the moment?
Yeah, so I think the boots on the ground is in some sense an easy case, right? It's a case where you want parliamentary approval, you want your troops to feel like they've got the support and that they can intervene. So it's almost like the minimal case. Since we've introduced this convention and since we expect Parliament to be involved, that's sort of an easy case. But I think I really liked your previous question and then James's response about the hypotheticals, because so one of the things that the current situations and the current consultation creates is this urgency, but also the rally behind the crown phenomenon, right? Where MPs feel they need to agree. Okay, we've got the Syria example, but generally MPs feel they need to agree, they need to support an intervention. And so it creates this urgency that doesn't allow us to think through the different situations. And I think especially with the changing types of war, so cyberfare, drones, I think those kind of hypothetical discussions would actually be specific enough, would actually be, I think, very welcome. And I think they would lead to sort of a clarification of under what circumstances are we happy with this to happen. The question is how much they would actually bound the government. But if I can sort of, underline one of the things you started with before, which you said, who is the convention? I mean, it is in the cabinet manual, so it looks like it's the government that's driving it. But, a few years back, and this is 2017, Haley Hooper and I wrote this book that's called Parliament's Secret War. And the title, and it's about the convention, and it's about a parliament being, consulted on decisions to go to war. And our view is that really it's the parliament, that the House of Commons, that should own this convention and that should ensure its involvement. And one of the chapters speaks about the possibility of secret sessions and how, that sharing of material, if that is the delicate bit, how that would occur. So I think there's a number of solutions. It's just there needs to be clarity from the political branches about what is it that is being sought. So what kind of involvement at what stage, and whether or not it depends on the type of war. And I think if we talk about hypotheticals, it doesn't need to depend on whether there's a targeted strike or involvement of troops on the ground.
And one kind of question that that comes up is not just how Parliament can be supported to express a view, but how it can be supported to express an informed view, and the potential for select committees to play into that, for secret sessions to be one way of tackling that is an interesting one. How much do you think parliamentarians want to do this? Is this something that we think would be pushing on an open door, or would we also be looking for some sort of cultural change among backbenchers to address some of that rally around the crown effect that Veronika talked about? David, why don't you give us your thoughts?
I think if we're in a situation where men and women of the armed forces are being deployed into action, there is a tendency amongst most members of Parliament, government and opposition sides alike, to rally behind them. And usually critics of a particular operation preface their comments by saying, I support our troops, but my questions are about the wisdom or the legality of the government's policy. So I think that effect is there. I do genuinely think that that a debate about a conflict and where MPs are being asked personally, each of them, to decide whether or not they endorse this course of action, does focus minds. And I do remember in 2003 how both Robin Cook's resignation statement and Tony Blair's opening speech in the debate a day or 2 days later on the government's government's motion to seek endorsement for the Iraqi operation were listened to by packed houses, and there wasn't sort of much heckling going on at all. The people knew this was deadly serious. So I think there is that willingness, and actually having motions that are amendable and votable reinforces that point.
Fantastic. It's high time that we brought in our audience for some questions. So I'm going to ask Tom to come back on screen. Tom, what do you have for us?
Hey, thanks, Lisa. So we've got a few different questions, and I'll take 4 in this round, but people can keep putting them in if more occur to them. So firstly, John Cartledge mentions that at various points we've been talking about Parliament, and he asks whether we mean both houses or only one, and if so, which I suppose raises the broader question of, is this just about the House of Commons, or is the House of Lords part of this discussion as well? Gavin Barlow then says that the start of military action is clearly important, but it can be difficult to define in itself, and it's not clear why it should be privileged over other decision points around escalation, changes of objectives, changes to the scale or nature of deployment. And so he asks, why has the debate around the convention become almost solely fixed on the initial decision on commitment? There are then 2 very closely related sort of comments here. One from David Nartzler, who points out that you don't necessarily need legislation. The Brown government had a detailed draft resolution ready and drafted in 2009. And in a similar spirit, Patrick Thomas has said that many of the positions here seem to be broadly in line with the 2019 report by the Commons Public Administration and Constitutional Affairs Committee. That report recommended that the House make a resolution setting out the expectation of the House being given a vote to authorise military force and a minister being required to make a statement if not. And so he asks whether the panel thinks such a resolution would be effective. And then finally, we've had a couple of different questioners ask about whether secret sessions or closed-door meetings of Parliament or of its select committees are really feasible, given that the risk of members choosing to reveal afterwards what was said in those meetings.
Okay, fantastic. So what role for the Lords? Why is the start of military action the place we focus? Is a Commons resolution the answer? And how worried should we be about leaks? James, I'll come to you first. Feel free to pick out any of those.
Thank you. I mean, on the question of the Lords clearly has huge expertise, right? You've got former chiefs of the defence staff in there, for example, not to mention former ministers. I focus on the Commons because it's the political part, it's where the real power lies. But there's also a constitutional dimension to this, which is the Bill of Rights. the legal architecture governing the Crown's right to raise and maintain armed forces was constructed in the aftermath of the Civil War and the Glorious Revolution. And so is framed very much in terms of the powers of the Commons over the Lords and Crown, on the basis of the expectation that the Crown pretty much had the Lords in its pocket. So that's why, actually, I think you could make a lot more use of the Lords, but I wouldn't use it in the same way. I'd use it more in the way it's used in terms of legislation. It's clearly a secondary house, but able to bring its expertise to bear. On the secret sessions, definitely wouldn't work. I'm being slightly facetious in throwing that in there. The context in which it was used in the World Wars was a context in which you could put MPs in prison if they leaked things, because particularly in the Second War, the government took on the legal powers to do anything it wanted. Obviously, that would not be practical or justifiable in the kind of more limited conflicts we've seen more recently. On the question of resolutions, I mean, I said this to the Public Administration Committee in 2019. I don't see why not. I don't know whether having a resolution would really change anything. I suppose you might clarify a few sort of specifics about what the expectations were, but attitudes change over time. And the question about what happens after the initial start of conflict, that is a really important question. And this is something that I think is really, really key. I think there's been far too much focus on the moment of deployment in recent debates, in a way that actually forgets the historical role that the House of Commons has played during extended conflicts in the past, right? I've rattled off a few historic prime ministers, but Lord North fell after the defeat at Yorktown, right, at the end of the North American War. Lord Aberdeen fell following the debacle of the winter of 1853 to 1854 in Crimea, 54 to 55 in the Crimea. Midway through the conflict, Herbert Asquith fell at the end of 1916. Neville Chamberlain fell after the loss of Norway in May 1940. So historically, actually, the Commons has played a major role in response to defeats, reverses, changes in the nature of the conflict. And I think it's one of the biggest weaknesses of the convention as it currently stands, that it is all about the moment of deployment and not at all about what happens when things change. And the key example here is Afghanistan, right? The deployment into Helmand province in Afghanistan in 2006, there was no vote because it wasn't the start of British action in Afghanistan. But in fact, it was the start of Britain's most intensive period of war fighting since Korea, arguably. And I think that was a real shortcoming. But again, also a failure of imagination. Failure to understand what that deployment would look like, and a failure to ask the question of, well, what if it turns out that we can't do this without a shot being fired? So I'll leave it there. Thanks.
Great. Thank you, James. Veronika, do you want to come in?
Yeah, so I'd just like to add, totally agree with James in relation to the points he made. So I'd just like to add on the start of military action that it is the convention and the wording of the convention in the cabinet manual that really singles that moment out, and that is, you know, in some sense it limits that involvement or the requirement for involvement. But in fact, there have been, I think, when the operations were extended in relation to in Syria in relation to ISIS, there was a vote on that, and I think that is something that needs to be considered. So any extension of conflict or deeper engagement would need to be debated in Parliament, and what it means and what the implications are. And I think Afghanistan is a really good point there. But it is the convention itself that has really singled that out. And I guess also the phenomenon that I mentioned before, the rally behind the Crown, the feeling that if you consult Parliament before any involvement or any engagement, that there's still chance to pull out. And I guess Syria 2013 is the example that shows, well, there was no involvement because the vote failed. So maybe that's the reason that it's been singled out, but I think there's no basis to stick only with that word before and prior involvement. I think it could be expanded, and Parliament could be more creative in that.
Okay, Thank you. And David?
I think just on the Lords, and I think that the Lords can contribute to the debate. They could have the emergency select committee meeting. Of course, you could have a plenary debate, but basically, James's point is the right one, that the powers of the House of Commons were really crystallised in the sort of late 17th century, beginning of the 18th century, when the Commons needed to be in almost continuous session to keep voting taxes through to pay for William III's wars. And so the powers of the Commons are just so intricately and intimately tied up with the Crown's need for resource, and it's the Commons that has the final say, and of course it's the Commons that's elected, and the Lords is not. So I do think the Commons is the key forum to be thinking about here. I'm a bit sceptical about completely secret sessions of the entire House. I do think you can make secret sessions of a select committee work. The ISC doesn't leak. Now, of course, the ISC members are appointed by the Prime Minister. Then, although we'll note now there's sort of a bit more of an elected element to it, but they have a sort of separate legal basis. But I think that if, for example, you said that members of the Defence Select Committee had to be vetted before they could take up their seats, that you wrote into common standing orders various requirements that would be needed. I mean, you could perhaps insist that everybody was a Privy Councillor who was on the Defence Select Committee, and that there were, pretty fearsome penalties available for a Defence Select Committee member who breached the terms of a secret session. And I do actually think this. So these are the same people who might next week be recruited into very sensitive ministerial offices and be expected to observe the Official Secrets Act and all the secrecy requirements of being in government. So I don't think that one should be too sort of pessimistic about any of that at all. I think there are ways of getting rid of this.
And what do you think, David, about this question of whether we should be thinking about Parliament's role in looking at escalation? We've talked very much about here the beginning of action.
The key thing there, because I'm actually thinking back, because it jogged my memory of John Reed's late night statement about UK deployment into Helmand, and this was what turned out to be a very, very costly operation in terms of soldiers' lives and also maiming of many soldiers there. And yet I remember John Reed, I'm sure in completely good faith, saying that this was a peacekeeping operation, that it might be that our forces didn't have to fire a shot while they were in Helmand. So the key to this, it seems to me, is to, again, it's going back to standing orders, and this is all, and it all can sound sort of terribly bureaucratic and fiddly, but actually get the procedure right, and then you can have some serious consequences. And it's giving the House of Commons greater power to determine its own timetable and its own business that is the key here, which is why I talked earlier about having something written into standing orders that either perhaps gave a power to the Backbench Business Committee to insist that in particular circumstances, conflict, that a debate would have to be held. The Speaker would have to give priority to a request by the Backbench Business Committee or the Leader of the Opposition. A number of ways to do it for a debate on this, and the Speaker would be obliged to call a substantive motion or empowered to. Again, you could make it permissive, or you could make it obligatory for the Speaker to call a substantive amendment if that were tabled. So you can write in all sorts of safeguards and as much detailed process as you want to do, but the key principle is let the House of Commons, through standing orders, have greater power to determine its own business, and that is what gives it the leverage over government.
Yeah, Yeah. One last, and I should say, we at the Constitution Unit are big advocates of giving the House of Commons some more power to determine the things it debates. See our recent report, Taking Back Control, from within the last few years on how this might be done. One last question, and I'll throw this open to anyone who wants to tackle it. We're obviously looking toward an election at some point in the next 10 months. What might convince an incoming government that pursuing reform in this area is a good thing to do? And how likely do we think that might be to happen?
I mean, I don't think you're going to convince an incoming government that reform in this area is a good thing. That there's a reason why this is something that parties are very keen on when they're in opposition, and they become less keen on when they're not in opposition anymore. This is an area where having a codified rights or more power for Parliament is good if you are in opposition, and starts to look a lot less good when you are in government. So I would be a little bit dubious about any substantive change. I mean, I would make all the arguments that I've made. I'd make the point that this is actually in your interests as a government. I didn't make a point that I often make, which is that one of the best ways, it's not the only way, but one of the best ways to win a vote on military action in the House of Commons is to make a good argument for what you're trying to do. And one of the best ways to make a good argument for what you're trying to do is to have a good plan in the first place. And I see in the questions, Sir David Natzler has referred to the debate in 2013 as a debacle, which is a kind way of referring to what happened over Syria in 2013. But part of the problem was that the government couldn't answer basic questions about what it was trying to do. And this was quite painfully exposed during the debate. And so it didn't really matter that the opposition also couldn't answer basic questions about what it was trying to do, because really what mattered was that the government was defeated. And of course, people tend to forget the opposition was also defeated, which is exactly what Sir David is referring to there. So have a good argument, make a good policy in order to have a good argument. If you can't persuade MPs to support what you're trying to do, it is possible that what you're trying to do is not a very good idea.
Fantastic. David, Veronika, we have a couple of minutes left if either of you would like to come with a final word.
I agreed with broadly with James's analysis on that one. So I don't have too much to have. Your question, the question was, well, just remind me, Lisa, was more about the broader issue there. So
yeah, well, was about how likely it is that an incoming government might be persuaded this is a good thing to do.
I was going to say, I think the tactic is probably not for Constitution Unit or anybody else to sort of go to whoever's the new Defence Secretary or Prime Minister. Say, right, you need to be doing this and exposing yourself to more control by Parliament. Actually, it's to have a campaign which leads to a proposal for reform coming from within Parliament. It's getting the procedure committee, probably going back to nitty-gritty stuff, to have a look at this in detail, and then for it the change to come forward as a proposal from Parliament's own members. That then becomes something with which the government has to engage, because at the very minimum it has to reply and publish a reply, and that then becomes a peg on which you can take forward the argument in more detail. So it's persuading MPs, and I'd be talking to the Procedure Committee and Defence Committee members, and probably ex-ministers about this, and trying to persuade them there's a need for Parliament to take this issue away and look at it in detail and come up with some proposals.
Fantastic. I see we've just tipped over to 1:15, so we'd better end what's been a fascinating discussion there. Very many thanks again to all of our speakers and to all of you for joining us. As I mentioned earlier, we'll be posting a video of this session on the Constitution Unit's website and YouTube channel, and we'll be releasing the audio version as an episode in the Constitution Unit podcast. So do encourage all your friends and family to have a listen. Join us again on the 25th of April. My colleague Alan Rennick will be chairing the next webinar in this series, Changes and challenges in regulating elections. A sign-up link has just appeared in the chat, and that panel will be with Laura Locke of the Association for Electoral Administrators, Lord Paul Tyler, and Professor Alistair Clark. If you miss the web link in the chat, you can find it on the events section of our website. But for now, that's it from us. Goodbye, and we hope to see you again soon.